Warm greetings everyone. I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In today's lecture, we will learn about guardianship under Hindu law. The learning outcomes of the present module are: firstly, the introduction about the topic, historical perspective, legal guardianship and custody, main objectives of the Hindu Minority and Guardianship Act 1956, then the powers of natural guardian, powers of testamentary guardian, welfare of minor to be paramount consideration, and finally the conclusion. Dear learners, let's begin with the prologue. In Hindu Dharam Shastras, not much has been said about guardianship. Classical Hindu law did not contain principles dealing with guardianship and custody of children. In the Hindu joint family, the Karta was responsible for the overall control of all the dependents and management of their property, and therefore specific legal rules dealing with guardianship and custody were not thought to be necessary. The ancient Hindu law had hardly a developed law on minority and guardianship. As discussed, the minor children mostly lived in a joint family and were always under the protection of the Karta. In the joint Hindu family, the Karta was obliged to protect the minors and the women and maintain them even after the death of the father or the husband, as the case may be. During the British regime, the law of guardianship was developed by the courts. It came to be established that the father is the natural guardian of the children, and after his death, the mother is the natural guardian of the children. And no one else can be the natural guardian of the minor children. Testamentary guardians were also introduced in Hindu law. It was also accepted that the supreme guardianship of the minor children was vested in the state as parens patriae and was exercised by the courts. Before a detailed discussions, my dear learners, let's talk about the historical perspective. According to JDM Derrett, the guardianship of minors is traditionally viewed as a right. The law, however, regards guardianship as a duty, which may be exercised only for the benefit of the minor. The Hindu law anciently left with the king the duty of protecting the property of minors, but very little beyond the general principles of minority and guardianship found its way into the textbooks. Since the commencement of the British period, it has been established law that the court is the ultimate guardian of all minors. He further elaborates that the tendency of Anglo-Hindu law was to give those properly interested in minors' welfare wide powers, when acting in their own names, to bind the minor's estate for purposes that were justified by the minor's necessity or for the protection or proper management of the minor's property. Let's understand the difference between legal guardianship and custody. The distinction between legal guardianship and custody has been aptly elaborated by JDM Derrett. According to him, legal guardianship and custody are two distinct concepts. The guardian may not have custody, but by virtue of his guardianship, he may still exercise powers regarding marriage and education and move the court, if need be, to reconsign his custody or to make other appropriate orders. Dear fellows, let's discuss the relevant provisions of the Hindu Minority and Guardianship Act 1956. The Act was passed to amend and codify certain parts of the law relating to minority and guardianship among Hindus. It received the assent of the President on August 25, 1956. It was the third part of the Hindu Code Bill. It consists of 13 sections. Section 2 of the Act makes it clear that the provisions of this Act shall be in addition to and not in derogation of the Guardians and Wards Act 1890. Who are minor children under the Act? Under the Hindu Minority and Guardianship Act, Section 4, Clause B, a minor means a person who has not completed the age of 18 years. A minor is considered to be a person who is physically and intellectually imperfect and immature, and hence needs someone's protection. In the modern law of most countries, childhood is accorded protection in multifarious ways. According to Section 3 of the Indian Majority Act, every minor whose person or property a guardian has been appointed or declared by any court, and every minor whose property the superintendence has assumed by the Court of Wards is deemed to have attained his majority at the completion of the 21st year, and in all other cases, the minor is deemed to have attained his majority at the completion of 18 years. Now, who is a guardian? The term guardian is defined by the Guardians and Wards Act 1890 as a person having the care of the person of a minor or his property, or of both his person and property. Thus, a guardian is known to be a person having the care and responsibility of the person of the minor or his property, or some cases both person and property. It may be emphasized that in modern law, guardians exist essentially for the protection and care of the child and to look after its welfare. This is expressed by saying that the welfare of the child is a paramount consideration. Welfare includes both physical and moral well-being. As discussed earlier, Section 4b states that guardian means a person having the care of the person of a minor or his property or both his person and property, and includes a natural guardian, a guardian appointed by the will of the minor's father or mother, a guardian appointed or declared by a court, and a person empowered to act as such by or under any enactment relating to any court of wards. Thus, under Hindu law, there are 4 classes of legal guardians: natural, testamentary, appointed by court, and guardian by affinity, that is marriage. Natural guardians imply the biological father and the mother of the minor. Adoptive parents are also natural guardians of a child. However, step parents are not considered to be natural guardians of a minor. As far as natural guardian of a Hindu minor is concerned, the bare provisions of Section 6 of the Hindu Minority Guardianship Act provide that the natural guardians of a Hindu minor, in respect of the minor's person as well as in respect of the minor's property, excluding his or her undivided interest in joint family property are: number 1, in the case of a boy or an unmarried girl, his father or her father, and after him the mother, provided that the custody of a minor who has not completed the age of 5 years shall ordinarily be with the mother. Secondly, in the case of an illegitimate boy or an illegitimate unmarried girl, the mother and after her the father. Thirdly, in the case of a married girl, the husband. In Hindu Shastras, husband and wife are considered to be one. Thus, it is believed that the guardianship of a minor wife belongs to the husband. However, due to Section 13, a court may revert the guardianship to the father or mother depending on the best interest of the minor, provided that no person shall be entitled to act as the natural guardian of a minor under the provisions of this section if he has ceased to be a Hindu, or he has completely and finally renounced the world by becoming a hermit, joining the Vanprasth, or an ascetic yati or sannyasi. Explanation: in this section, the expressions father and mother do not include a stepfather and a stepmother. Now, what is the role of mother as a guardian? In Geeta Hariharan versus Reserve Bank of India, 1999, the apex court held that Section 6A itself recognizes that both the father and the mother ought to be treated as natural guardians, and the expression after therefore shall have to be read and interpreted in a manner so as not to defeat the true intent of the legislature. Be it noted further that gender equality is one of the basic principles of our Constitution, and in the event of the word after is to be read to mean a disqualification of a mother to act as a guardian during the lifetime of the father. The same would definitely run counter to the basic requirement of the constitutional mandate and would lead to a differentiation between male and female. The father, by reason of his dominant personality, cannot be ascribed to having a preferential right over the mother in the matter of guardianship. The court observed that the word after does not necessarily mean after the death of the father. It rather implies in the absence of father, be it temporary or otherwise, total apathy of the father towards the child or even inability of the father by reason of ailment. Natural guardianship of an adopted son. Section 7 of the Act provides that the natural guardianship of an adopted son who is a minor passes on adoption to the adoptive father and after him to the adoptive mother. From the moment the minor is adopted by a person, it is the adoptive father that becomes the natural guardian, and the natural parents cease to be the natural guardians. Further, the comments under Section 6 would equally apply to the adoptive parents as natural guardians of the minor. My dear learners, now let's discuss about testamentary guardian. A guardian designated by the natural guardians via a will is known as a testamentary guardian. But no one else has the authority to name a guardian by will, only natural guardians do. Here, an intricate situation may arise. If the child's mother and father have named different guardians in their wills. In such a case, if the father dies, the guardian appointed by him through his will has no power to act as the guardian of the minor, as the minor's mother, a natural guardian, is still alive. However, if the mother also dies, then the will of the parent who died later, in this case, the mother, will operate. Moving further, there is a de facto guardian. A guardian appointed by law is called a de jure guardian, while a de facto guardian is not appointed by the law, but nevertheless plays the role of a guardian of the person or property of a minor. However, it is pertinent to note that a de facto guardian cannot transfer the property of a minor except with the prior permission of the court. Dear viewers, now let's discuss the powers of the natural guardian. As per the provisions laid down in Section 8, the natural guardian of a Hindu minor has the power to do all the acts that are necessary, reasonable and proper for the benefit of the minor or for the realization, protection or benefit of the minor's estate. But the guardian can in no case bind the minor by a personal covenant. The natural guardian shall not, without the previous permission of the court, mortgage or charge or transfer by sale, gift, exchange or otherwise any part of the immovable property of the minor, or lease any part of such property for a term exceeding 5 years or for a term extending more than 1 year beyond the date on which the minor will attain majority. Any disposal of immovable property by a natural guardian in contravention of these provisions is voidable at the instance of the minor or any person claiming under him. It is noteworthy that a court shall grant permission to the natural guardian to mortgage or lease the property of a minor only in cases of necessity or for an evident advantage to the minor. The natural guardian has the power to enter into contracts and to do all other acts that are reasonable and proper for the protection or benefit of the minor's property and for the advantage of the minor. But the guardian cannot in any case bind the minor by personal covenant, though the minor's estate may be liable. Moving further, we will discuss the powers of testamentary guardians. Section 9 lays down that a Hindu father entitled to act as the natural guardian of his minor legitimate children may by will appoint a guardian for any of them in respect of the minor's person, in respect of the minor's property or in respect of both. However, a father has no power to appoint a guardian by his will of the undivided share of his minor son in the joint family property. The undivided interest of the minor in the joint family property must remain in the hands of the karta or manager. He can appoint guardians by will only for the person and the separate property of the minor. Secondly, an appointment of a testamentary guardian by the father shall have no effect if the father predeceases the mother, but shall revive if the mother dies without appointing by will any person as guardian. Thirdly, a Hindu widow entitled to act as the natural guardian of her minor legitimate children and a Hindu mother entitled to act as the natural guardian of her minor legitimate children by reason of the fact that the father has become disentitled to act as such, may by will appoint a guardian for any of them in respect of the minor's person or in respect of minor's property or both. A Hindu mother entitled to act as the natural guardian of her minor illegitimate children may by will appoint a guardian for any of them in respect of the minor's person, in respect of the minor's property or in respect of both. The guardian so appointed by will has the right to act as the minor's guardian after the death of minor's father or mother, as the case may be, and to exercise all the rights of a natural guardian under the Act to such an extent and subjected to such restrictions as specified in this Act and in the will. The right of the guardian so appointed by will shall, where the minor is a girl, cease on her marriage. We must know that incapacity of a minor to act as guardian of property is also provided under the Act. A minor shall be incompetent to act as guardian of the property of any minor. Section 21 of the Guardians and Wards Act 1890 provides for the capacity of minors to act as guardians. As per this provision, a minor is incompetent to act as guardian of any minor except his own wife or child, or where he is managing member of an undivided Hindu family, the wife or child of another minor member of that family. Act provides that de facto guardian not to deal with minor's property. After the commencement of this Act, no person shall be entitled to dispose of or deal with the property of a Hindu minor merely on the ground of his or her being the de facto guardian of the minor. In Khudiram Mukherjee versus Banwari Lal Roy, 1889, the court observed that under Hindu law, the relatives of the deceased husband are entitled to be the guardians of a Hindu widow in preference to her paternal relations. Further, guardians not to be appointed for minors' undivided interest in joint family property. Where a minor has an undivided interest in joint family property and the property is under the management of an adult member of the family, no guardian shall be appointed for the minor in respect of such undivided interest, provided that nothing in this section shall be deemed to affect the jurisdiction of a high court to appoint a guardian in respect of such interest. Here, it is pertinent to note that the Act provides that no guardian for a minor's undivided interest in joint family property is to be appointed, as the karta in a Hindu joint family is the manager of all property belonging to the family. The coparcenary interest of the minor is not his individual property. In Hanuman Prasad Pandey versus Musammat Babu Manraj Kumar, 1856, the court held that a karta or manager has power to alienate a minor's property. However, it is a limited power and it can only be used in an emergency or for the advantage of the estate. Most importantly, welfare of minor is to be paramount consideration. Section 13 provides that while deciding the guardianship, the welfare of minors shall be of paramount consideration. The welfare of the child as a criterion for decision is generally flexible, adaptable, and reflective of contemporary attitudes regarding family within society. In the appointment of any person as guardian of a Hindu minor by a court, the welfare of the minor shall be of most important consideration. No person shall be entitled to guardianship by virtue of the provisions of this Act or of any law relating to guardianship in marriage among Hindus, if the court is of the opinion that his or her guardianship will not be for the welfare of the minor. My dear learners, it is concluded that while deciding the question of guardianship, the dominant matter for the consideration of the court is the welfare of the child. But the welfare of the child is not to be mired by money alone or merely physical comfort. In considering what will be for the welfare of the minor, the court shall have regard to the age, sex, and religion of the minor and the character and capacity of the proposed guardian and his nearness to the kin of the minor, the wishes, if any, of a deceased parent, and any existing or previous relations of the proposed guardian with the minor or his property. With this, we conclude our today's module. Thank you very much.